Appeal in the matter of Inmarsat Global and HMRC.
Good morning.
Yes, Mr. Russell.
I appear with Ms. Barbara Belgrano for Inmarsat, the appellant company, and Mr. Gibbon QC, Mr. Velat QC, and Mr. McGee appear for the respondents HMRC. Could I just check that you've got the appropriate bundles? There should be a core bundle, a supplementary bundle, and a bundle of 2 files of authorities.
Yes.
I've got that, yes.
There is one tab, another authority which HMRC wish to add, at tab 46, the very end of the authorities.
Right. Well, we do have an usher who can, or do we? Can't quite see. If not, perhaps my clerk would hand that up. Thanks.
I'll address the point of rising tomorrow, if I may.
Yes. We just got that. Well, shall we, for good order's sake, put it straight in? No doubt behind tab 45 is where you would recommend.
There is also a transcription service, apparently.
Yes.
And I don't know whether the court would want to have a break for the transcribers.
Well, I'm afraid I'm rather ruthless about that. I don't have a break for the trial, unless if they ask for it to make a strong case. I suppose my heart could be softened, but it does actually interrupt matters.
Yes, and time is quite tight, so I would be happy not to have one.
Right. Well, when we first looked at these papers, we wondered whether 2 days was too long. We then agreed it probably wasn't, but I don't think time is tight for this case.
Fair enough. What Mr. Gibbon and I have agreed, subject to the court's comments, is that I would have today to make all of my submissions on section 78(1) and 61(4), and then Mr. Gibbon will have tomorrow, except for the last hour when I have my reply. We're both happy with that if the court is.
Right. Well, the court can't object because it's sort of a two-day estimate. We have, of course, read the papers quite carefully. It's difficult. We do understand that, so we're not asking you to rush it at all. No. But I would be a little bit surprised if it took you all day, but we'll see, won't we?
Yes.
Right.
Well, the relevant facts are not controversial and are summarised at paragraph 12 of my skeleton.
Yes.
At this stage, it's sufficient to say that a number of satellites were built and launched into orbit and used by an intergovernmental body called IMSO in its telecommunications trade in circumstances where the satellites had been purchased by finance lessors and leased to IMSO, but IMSO had paid the very substantial launch costs. And then, in 1999, the 15th of April, Inmarsat succeeded to IMSO's trade, becoming lessee of the satellites pursuant to novation agreements with the finance lessors, and thereafter using the satellites in the continuing trade, its trade. And the issue in those circumstances is whether Inmarsat is entitled to writing down allowances under Section 24 of the Capital Allowances Act 1990. And if I could take you to tab 9 of the bundle of authorities, which sets out provisions of the 1990 Act, and page 44 is where we find section 24. At the very bottom of page 44, subject to the provisions of this part, where a person carrying on a trade has incurred capital expenditure on the provision of machinery or plant, wholly and exclusively for the purposes of the trade, and in consequence of his incurring that expenditure, the machinery or plant belongs or has belonged to him, allowances and charges shall be made to and on him in accordance with the following provisions of this section. I'm just going to stop there before I will go on to the provisions in section 24 and 26 because they are important. But just stopping there, I call those two conditions the expenditure condition in A and the belonging condition in B. Regarding the expenditure condition, one might be forgiven for thinking, as I think both parties did below and the upper tribunal did as well, that the words wholly and exclusively for the purposes of the trade relate to the incurring of the expenditure. But it appears from elsewhere in the Act that the words actually relate to the provision of the machinery or plant. And if I can just give a very quick example, on page 113, this is section 81.2. This is relevant to a point which the upper tribunal made.
So sorry, I'm being rather slow.
Yeah.
Yeah, sorry, where were we going?
Page 113 in the same tab. This is section 81.2. I don't need to read earlier provisions of 81, but 81.2, where subsection 1 above applies, the question whether the provision of the machinery or plant is to be taken to be wholly and exclusively, only partly for the purpose of the trade, shall be determined according to, and so on. I can give other examples, but the legislation, when it talks about wholly and exclusive for the purpose of the trade, is actually focusing on the provision of the plant, not the incurring of the expenditure. I'll come back to that later in relation to a paragraph of the upper tribunal's decision. This was
on the face of it, sorry, yeah, you're coming back to it later, I probably shouldn't have asked you to anticipate. On the face of it, it's difficult to imagine circumstances in which it would make much difference, but you're going to show us one where it may.
Well, we're in the section 78.1 world, which on any view is a sort of fictional world, and one of the questions the tribunal had to consider when choosing between the alternative interpretations of myself and Mr. Gibbon is whether the requirement, the wholly and exclusively requirement, points to there being actual ownership on the part of the
Yes,
successor.
I see. Well, I'm sorry, it's my fault. You'll come to it.
I'll come
I
back.
I see how it fits into that
But I'm just
point.
just making it now.
No, thank you, that's helpful.
And then in relation to the belonging condition in 24.1b, it's clear following the decisions of the Court of Appeal and then the House of Lords. The Court of Appeal case is one called Stokes and Costain. It's in the bundle, but we don't need to go there. And the House of Lords decision is one called Mellowish and BMI number 3. Again, it's in the bundle, but we don't need to go there. To the effect that the concept of belonging refers to absolute ownership. That's what belonging means, being the absolute owner. So that a lessee is not an owner, obviously, and therefore machinery or plant cannot belong to a lessee. And the final point I want to make in B, you see that it says the machinery or plant belongs or has belonged to him in B, so that when we look at entitlement to writing down allowances, there is no requirement of continuing belonging. Has belonged is good enough. Now,
Can I just ask,
yes.
sorry, are you developing that point or moving to a new one?
No, I'm moving on.
I was just slightly puzzled when I first read this by the rather convoluted wording of B.
Yep.
In consequence of his incurring that expenditure, the machinery or plant belongs or has belonged to him. I mean, the paradigm case obviously is the expenditure is the purchase price.
Yep.
I can see that it helps some aspects of your argument that convoluted wording is used. But in a non-lease situation, are there other examples where you can acquire plant in consequence of incurring expenditure which isn't simply paying the price for it?
Well, I'll come to some examples of where you can incur capital expenditure on the provision of machinery or plant without it, in consequence, belonging to you.
Yes, I'm talking about asking the
You're
reverse
asking a different
question.
Can machinery or plant belong to you in consequence of the expenditure other than
Paying the purchase price.
paying the price? Well, it's clear from some a couple of House of Lords cases I'll be taking to you, one called Berkeley Curl, another one called Ben Oderco, that the concept of incurring expenditure on the provision of machinery or plant can include something like transport or installation costs. Now, it's clear, it's common ground, that is so where the person who's creating or buying the machinery or plant is the person incurring those costs.
But that's because, as I read it, that's because, as it were, delivery of the plant you're buying is part of the purchase transaction, it's part of the purchase obligations.
No, with respect, there need be no such requirement. Certainly HMRC haven't suggested there's any such requirement, and I don't think you can read that from the cases, where it's perfectly possible that one is contracting with a particular person to buy it or to have it made, and with another person to have it transported to the place where it's going to be used.
Yes, but paying the transport costs in that case wouldn't, in consequence, wouldn't have the consequence of you becoming the owner.
It wouldn't if you're focusing on each separate element of the expenditure. But if you're looking at the global expenditure and saying, I've incurred capital expenditure on the provision, which I want to claim allowances for, and incurring that expenditure, including parts of it, the machinery or plant belongs to me. That, in my submission, must be the correct interpretation, given what the House of Lords has said about
those cases, those dicta about transport costs in the dry dock.
They don't say that it has to be part of the same contract with the same person who you're buying it from or getting it made for you. But B, I would submit, is a separate question from A. The belonging question, the belonging condition, is a separate condition from A. It's when we come on to section 61.4, which is the lease provision, and this may be a point that my Lord Justice Underhill was making, really, that the only question is whether the lessee has incurred capital expenditure on the provision. And if he has, well, obviously there's a bit more to it than that, but if he has, then section 61.4 says it's deemed to belong to him. So that one doesn't have a requirement of belonging, clearly, in order to have it to be deemed.
Well, I see that, and if you're right on section 61, you perhaps get over this difficulty, but it's different. It may not be a difficulty, but section 61 tells you what the answer is.
Yeah.
I just like to understand everything if I
Yes,
can, and I'm still puzzled by, in a non-lease situation, what kind of expenditure other than paying the purchase price has the consequence of the plant belonging to you.
Well,
and you've given the examples, which because I've seen the cases, you say are examples.
In a sense, I've answered it by saying, well, there aren't any others, clearly, except that the concept of incurring that expenditure is a reference back to the expenditure in A.
Yeah, of course.
And that is expenditure on the provision, so that the expenditure within A on the provision, clearly it's common ground in the paradigm case of the purchaser who also incurs transport costs. It covers all those costs. And the reference to incurring that expenditure, it is in consequence incurring that expenditure. It's true it's only the purchase part of it, but nevertheless, in consequence of incurring the expenditure which you want to claim allowances on, which is your capital expenditure, the machinery or plant belongs to you. So the legislation, when it says that expenditure, is not dividing up the expenditure between the purchase price and the transport cost.
No, well, I see that, and assuming the cases do indeed say that when one looks at them, that's one answer.
Yeah.
But I can't think of any other.
No, but I accept a paradigm, possibly the only case where something belongs to you in consequence of incurring particular expenditure, is expenditure that makes you the owner. That must be so.
Yeah, thank you.
Well, Inmarsat's case, as you know, is that both conditions were deemed to be satisfied, even though Inmarsat didn't actually incur any capital expenditure, and the satellites didn't actually belong to it. Both of those conditions were deemed to be satisfied by operation of Section 78(1) of the 1990 Act, which I'll be taking you to, which applies where there's a succession to a trade. It's common ground that where Section 78(1) operates, it deems the successor to incur capital expenditure on plant or machinery equal to its market value, so as to satisfy the expenditure condition, because it's deemed to be a purchase. But the debate is around whether Section 78(1) operates to deem the successor to acquire, to become the owner, for it to belong to the successor, or whether that's, as HMRC put it, just an assumption behind the legislation that that will in fact be the case, and the section simply doesn't operate unless it is in fact the case. So HMRC's case is section 78.1 only operates if the plant, let's say, actually belongs to the predecessor and then actually belongs to the successor. And in those circumstances, section 78.1 operates to deem the successor to incur expenditure, and that's all it does. Now, the upper tribunal agreed with HMRC in relation to that point about what work section 78.1 does, and that's why Inmarsat is appealing. But this case isn't just about the correct interpretation of section 78.1, because, as I will go on to explain, Inmarsat accepts that in order for section 78.1 to operate, the plant must belong or be deemed to belong to the predecessor before the succession. That's partly because of the words shall be treated as sold. You can't sell something that doesn't belong to you. So Inmarsat accepts that the plant must belong or be deemed to belong to the predecessor before the succession. And that's where section 61.4 comes in, because obviously the satellites did not actually belong to IMSO, the predecessor. IMSO was a lessee, but section 61.4, we say, operates to deem the satellites to belong to IMSO, so as to entitle it in principle to qualify for allowances in respect of its launch costs, and therefore that requirement of section 78.1 was satisfied. So I need to take you to 78.1 and 61.4.
Is it right, just as a question of fact,
Yep.
that IMSO didn't in fact claim any capital allowances
Well,
because it didn't need to, or
it couldn't because it was exempt from tax.
Okay.
But it's common ground that that isn't sort of relevant.
No, that's
to
not.
this.
That's not an obstacle.
It's not an
But
obstacle.
what it does mean is that when Inmarsat comes along in 1999, it then claims allowances that historically haven't been claimed, and it
Yes.
does so because of its different status as a
It does so
taxpayer.
because of its different status. But no, it's not suggested that that's
No,
sort of a
just,
reason against it.
no, I understand.
It may, at various points in the argument, be a useful thought experiment to see what would the position have been if IMSO had not been exempt.
Yes, absolutely. And my submission is that section 78.1 is postulating a predecessor who is not exempt and who, on the succession, is required to bring what's called a disposal value into account, which is, because it's a succession, is equal to the market value of the plant. And my submission is that section 78.1 is seeking to put the successor, as it were, into the shoes of the predecessor, so that, because it's a continuing trade, although it's deemed to be a permanent discontinuance of the predecessor's trade, nevertheless it is in fact a continuing trade, so as to ensure that allowances continue to be available for plant that's in use in that continuing trade. That's what my
Well,
submission is.
you're getting ahead of, yes.
I am getting ahead.
You're about
I'm
to
sorry.
take us to section. No, that happens when we ask questions, but
Well,
you're about to take us to section 78,
well,
aren't you?
no,
not yet.
well, what I was going to say before I do that, if I may, so we're looking at two deeming provisions. It shouldn't be thought odd that we're looking at deeming provisions. In the Capital Allowances Act 1990, I've had a go at counting these. There's over 200 deeming provisions in the Act, with words like shall be deemed, shall be treated, or the provisions of this part of this Act shall take effect as if. So there are lots of deeming provisions all over the place. In the relevant part of the Act, which is to do with plant and allowances, Part 2, there are over 80 of those provisions. And excluding section 78.1, because that's obviously up for grabs, as it were, there are 12 which deem plant, I'll call it just plant if I may, rather than machinery and plant every time, which deem plant to belong to someone to whom it doesn't actually belong. So there are quite a lot of provisions with this deeming effect. So it's by no means unusual in my submission to be considering, first of all, deeming provisions, secondly, deeming provisions where Parliament has considered clearly that there are good policy reasons for giving allowances to someone in circumstances where one of the conditions is a belonging one, by deeming the plant to belong to them. Now, there's no disagreement about the correct approach to the interpretation of deeming provisions, both parties agree with what the upper tribunal said at paragraphs 39 to 47 of its decision. Perhaps I can just leave it at that, or shall I take you to and ask you to read those provisions, those paragraphs?
Well, speaking for myself, I didn't detect any real problem about the right approach in law, so
no.
I'm content just to say that's an accurate summary.
What I would
So
like
that was 39 to 47.
39 to 47.
Yep.
What I would like to do, however, is to take you to one paragraph of a decision of the Supreme Court in a case called Fowler, where the Supreme Court did consider...
They put it all together quite
Put it all
helpfully,
together,
don't they?
exactly.
Yes, Lord Briggs.
So, if I could just take you to that. That is tab 25 of the authority bundle. So it's the end of this particular file, near the end. The facts aren't relevant because it's just a general statement at paragraph 25 of Lord Briggs. Sorry, paragraph 27 of Lord Briggs.
Yeah.
It's page 293 at the bottom of the page. So I could just ask you to read paragraph 27.
Yes, certainly.
And I'll be reminding you, if I may, when we come particularly to section 61.4, one of the points HMRC make is that if the plant is deemed to belong to the lessee, then it can't belong to the lessor, and therefore that prevents the lessor claiming allowances for the expenditure it incurs. My submission is that if one focuses on the purpose of the deeming, between which persons and for what purposes is this plant deemed to belong to the lessee, it's to give allowances to the lessee, it's not to deprive the lessor for allowances on his expenditure. Anyway, could I then go back to...
Just a footnote on Fowler, this is an example of a case, isn't it, where the Court of Appeal went too far. I think the Supreme Court said that the deeming provision couldn't go as far as the Court of Appeal had said it should, and that the purpose was a narrower purpose than the Court of Appeal had said, so they pulled it back.
And, yes, each of us is accusing the other of making that mistake.
Right.
HMRC say I'm making that mistake in 78.1, I'm saying they do in 61.4. That's just a fact, kind of thing. If I could take you back to section 24, and just very briefly explain how these allowances work. On page 45, if I could take you to subsection 2 of 24, subject to subsection 3, which is not relevant, for any charge in the period for which a person within subsection 1 above, that's the person who satisfied both those conditions, has qualifying expenditure, just stopping there, that's defined in section 25, but we don't need to worry too much about that. I'll mention it in a moment anyway. Which exceeds any disposal value to be brought into account in accordance with subsection 6, or shall be made to him, unless the period is related to the permanent discontinuance of his trade, a writing down allowance equal to 25% of the excess. Don't worry about little 2. And B, if the period is related to the permanent discontinuance of the trade, an allowance, a balancing allowance, equal to the whole of the excess. So just stopping there, one has to effectively put any qualifying expenditure that qualifies under subsection 1 into a pool, and then you calculate each year how much qualifying expenditure have you got left, as it were. So qualifying expenditure is the balance remaining after you've got allowances for the previous year. How much have you got left, and how much of that, if any, exceeds disposal values that you have to bring into account? And if you do have such an excess, then you get writing down allowances on 25% of it. And you'll see, because the expenditure goes into the pool, we're not interested in whether a particular plant still belongs to you. It's just been pulled, and that's why it's or has belonged. So that's if you have an excess of qualifying expenditure over disposal values.
Say that if it doesn't still belong to you, there may be a disposal.
Ah, yes, absolutely. There may have been a disposal. If it ceased to belong to you, we'll come on to that. There would be a disposal event and a disposal value, but subject to the amount of that value, that doesn't affect the fact that you've still got expenditure which qualifies.
Yes.
Yeah? And then if we go to subsection 5, so here's looking at the different situation. For any period for which a person's qualifying expenditure is less than the disposal value, which he's required to bring into account, there should be made on him a charge, a balancing charge, equal to the difference. So that's where you've got more disposal values than qualifying expenditure. You have a charge. And an example of that could be where there's, let's say, a sale. We'll come on to disposal values, but where you could have a sale of an asset and you've effectively received more allowances than the amount of the depreciation of the asset. So when you sell it, you bring in a disposal value greater than the qualifying expenditure that you've got left.
Yeah, because it hasn't depreciated by as much as allowed for. Yeah.
And then subsection 6 tells us what, or rather when you have to bring a disposal value into account. The disposal value to be brought into account is the disposal value of all machinery or plant, A, on the provision of which he's incurred capital expenditure, B, which belongs to him at some time in the chargeable period, and C, in respect of which, in the chargeable period, one of the following events occurs, namely. Then 1 is it ceases to belong to him, 2, he loses possession of it, where it's reasonable to assume the loss is permanent. So you might still own it, but you lend it to somebody else on terms, or you let somebody else use it on terms that you're not going to get it back, the possession back. 3, it ceases to exist. 4, it begins to be used for purposes other than those of the trade. And 5, the trade is permanently discontinued, or is treated by virtue of any provision of the Tax Act as permanently discontinued. Now those words in brackets, they refer in particular to 2 provisions of the Taxes Act, sections 113 and 337. When we come on to section 78.1, you'll see those are specifically referred to in section 78.1. They are provisions which apply to say that when an individual, in the case of 113, or a company, in the case of 337, ceases to trade, that is deemed to be a permanent discontinuance of the trade, even though there is actually a succession to the trade, someone else carries it on. So it's a deeming provision which says the trade is deemed to be permanently discontinued. And that has certain consequences, one of which here is that that is an event on the occasion of which a disposal value has to be brought into account by the person who ceased trading themselves, even though it's a succession. And then it says, and that is the first such event to occur. So it's the first of those various events. And then it says that this subsection shan't require a person to bring into account the disposal value of any plant which he... sorry, we don't worry about that, that's the wrong provision. So then, if one's decided that there is an occasion on which a disposal value has to be brought into account, one then goes to section 26 on page 48 to find out what that disposal value is. So, for the purpose of section 24, the disposal value of any machinery or plant depends on the event by reason of which it falls to be taken into account. And A, unless B applies, if the event is the sale, then it equals the net proceeds to the person in question of the sale, together with any insurance monies and so on. B is where it's a sale at a price less than would it fetched if sold in the open market. And then it equals the price which the machinery or plant would have fetched if sold in the open market. So A and B are both dealing with sales, but A is where it's not within B. In other words, it's as it were, a proper arm's length sale, and B is where it's not a proper arm's length sale. And if B applies, it's open market value. C, if it's destruction or demolition, the net amount received by way of insurance and so on. D, if it's the permanent loss of the machinery or plant, any insurance monies. E, if it's the permanent discontinuance of the trade before an event within A, B, C, or D above, is the same as the disposal value specified in the last mentioned event. So that would be a case where there is a permanent discontinuance of the trade, or a deemed one, followed by some event like a sale. And if it's the permanent discontinuance followed by a sale, then you go back to A and B to determine what the disposal value is. We don't need to read EA down to EE because those are all to do with software. But if you go down to F, in the case of any other event, equals the price which the plant would have fetched if sold in the open market at the time of the event. Now, F covers the case where there's a permanent discontinuance of the trade, not followed by a sale. Because it's a disposal event within section 24, permanent discontinuance. And because it's not followed by a sale, it's not within A or B. So it's F, the price which the machinery or plant would have fetched if sold in the open market at that time. Now, as I understand it, the thinking behind when you have a permanent discontinuance of the trade but no sale, so no monies are received, but nevertheless that is a disposal value, market value to be brought into account, is that in circumstances where the trader has got allowances and ceased trading, to the extent of any remaining value of the plant, he shouldn't get any more allowances. Or if he has had allowances already exceeding the current value, then there should be a balancing charge. I'm simplifying it slightly because obviously the legislation looking at the pool could include other machinery or plant kind of thing. But if we just take it simply as a case where there's one item of plant, let's say, and the analysis is just as good. The trader spent 100, it's now worth 50. Let's suppose that the trader has claimed allowances has got allowances of 50 so far. By bringing in 50 as a disposal value at that time, the trader had qualifying expenditure of 50, but less disposal value of 50, therefore no more allowances. And that makes sense that he should get no more allowances because he's not trading anymore. So that's the thinking behind F. But then one asks, well, what happens if, although from the trader's point of view, the trade has ceased, it's a permanent discontinuance, or deemed to be one, in fact, the trade continues. And there are succession provisions in the legislation which deal with that situation where the trade actually continues. And I'm going to take you to those in a minute, if I may, because my submission is that the purpose of these succession provisions is to ensure that allowances continue to be available, given that although it's deemed to be a permanent discontinuance, in fact the trade continues, and therefore allowances should be available for the plant that continues to be used in the continuing trade.
Even though the successor hasn't incurred the qualifying expenditure?
Well,
sort of ex hypothesi, if I could use a Latinism.
Yes, absolutely.
But you say they carry on as if, they stand in the shoes
I'm
of...
going to give you some, take you to the succession provisions where the fact that the successor has not incurred any expenditure is not relevant. And just for for completeness, HMRC accept in this case that where the plant actually belongs to the successor, after the succession, HMRC accept that Section 78(1) operates to deem the successor to incur expenditure, even though he hasn't actually incurred any because it wasn't a sale. So on any view, Section 78(1), again, as we'll see, it operates only when there's a succession, is a provision which deems the expenditure to be incurred when it hasn't actually been. But I'll take you to the other succession provisions as briefly as I can to show you that general trend, as it were, that general object. But before we leave Section 26, there's one point I wanted to make about this concept of, in F in particular, the price which the machinery or plant would have fetched if sold in the open market at the time of the event. Because this concept of a deemed sale obviously is central to section 78.1 as well. And the point I wanted to make here is, it may be that Lord Justice Newey in particular would be familiar with estate duty and inheritance tax, where there was a common expression of if sold in the open market at that time of death usually. And there are two cases which are in the bundle. One of them is well, they're both House of Lords cases, but they both make the point in my submission that this concept, this deeming of if something is sold, means that property, full ownership in the thing, is to be taken to be acquired by the purchaser. Of course, that makes complete sense, because if you ask, well, what would the price be if the plant had been sold in the open market, one's got to postulate that the purchaser becomes the owner.
Well, of course. I mean, that's too obvious to need stated.
Right, good, thank you.
But not the way it may not it gets you where you think it gets you, but
let me just explain now where I believe it gets me. One of the questions below was, what's the effect of the deeming in section 78.1 that the plant is deemed to be sold to the successor? And the upper tribunal asked itself whether it was a necessary consequence of the deeming that the successor becomes the owner, and therefore that it belongs to the successor. My case is, actually, I'm not saying it's a consequence. I'm saying that to deem the plant to be sold to the successor means that ownership passes.
Well, it does, but for what purpose?
Well, yes.
If it's just a thought experiment to find out what is the market, or not a thought experiment, it's just a necessary part of establishing the market value. Means what would you get if you sold it to someone? It's done its job when it's arrived at a figure.
Right. But so I accept that it could be, and this is obviously HMRC's case, this is merely a valuation mechanism. And it only operates if, in fact, the plant belongs to the successor. But, so my point is a more limited one than that, in that when one goes back to Fowler, paragraph 27, and the reference to East End dwellings, and not bolding at the consequences kind of thing, all I'm saying is this isn't so much a mere consequence. That's the way the upper tribunal put it. Is this an inevitable consequence of the deeming? I'm saying, and I accept that you have to ask for what purpose, but I'm saying it's not a mere consequence. It is the very meaning of the words themselves, the natural meaning of the words themselves, and I accept that you then have to ask, but is that the purpose of the deeming? Well, I mentioned that there are special succession provisions, and my submission is that all the succession provisions I'm going to take you to have this general overall object of achieving a sort of tax neutrality, because although there is a discontinuance of a trade, actually the trade continues. It's a succession. And the first of those is section 77. Which is on page 109. Now, what section 77 does is to provide that, and you'll see 77.1, where a person has succeeded to a trade which until that time was carried on by another person, and they're connected, then they may elect that A, the trade is not discontinued, B, allowances and charges shall be made to or on the successor, as if everything done by the successor had been done by the predecessor, done by the successor, with no account being taken of the sale or transfer from the predecessor to the successor of any plant in use at the time of the succession. What that one is doing is saying, that the successor steps into the shoes, as it were, of the predecessor for all capital allowances purposes. The successor gets the allowances that the predecessor had been entitled to without any disposal value being brought into account by the predecessor. That is as it were, the purest way of achieving tax neutrality, because it's neutral as between, there's no charge on the predecessor, and as I say, the successor simply steps into his shoes. That only applies, looking at subsection 2, for successions up until July 1988. And it's subsection 3 that applies after that. And although it's worded in a different way, it actually, in my submission, achieves exactly the same effect. So 3 says, a person succeeds to a trade which until that time is carried on by another person. They're connected. So each of them is within the charge to tax in the UK. That's a new requirement, as it were. Then they may give notice to the inspector. So that's like a joint election again, to elect that the provisions of subsection 4 shall have effect. And then 4 says, in the event of an election, for the purpose of making allowances and charges, any machinery or plant which, 1, immediately before the time when the succession took place, belonged to the predecessor and was in use for the purpose of the trade, and 2, immediately after that time, belonged to the successor and was in use for those purposes, shall, notwithstanding any actual sale or transfer, be treated as sold by the predecessor to the successor at a price which doesn't give rise to a balancing allowance or balancing charge, and B, allowances and charges should be made under this part to or on the successor, as everything done to or by the predecessor had been done to or by the successor. So actually that achieves the same object by deeming there to be a sale which doesn't give rise to a balancing allowance or balancing charge. That just means that the predecessor doesn't get allowances anymore or charges, and the successor steps into his shoes in the sense that he's deemed to have incurred capital expenditure equal to the remaining qualifying expenditure of the predecessor. And then we're told that everything done by the successor, by the predecessor, is deemed to be done by the successor. So that achieves exactly the same result. The difference, obviously, between 4 and 1 is that we've got these express requirements of belonging in subsection 4.
You're going to say something later about why that's done, why there's that difference.
Well, I will do when I get to section 38.1. I'm going to say that clearly Parliament, when it wants to, say that there must be a belonging before and a belonging by the successor after, it says so. But I will come back to that point if I may.
Is there any other... I mean, clearly, if you analysed it, there are all sorts of differences between subsection 1, which is relatively economical, and subsections 3 to 8, which are rather elaborate,
yeah,
even though you say they come to much the same thing.
Yeah.
But is there any historical reason why post-88 there was this much more elaborate definition? There are some substantive differences in there, aren't there?
Yes, there are.
Well, what are the key ones?
Well, the key ones are, first of all, in 3B, each of them must be within the charge to tax. Then in 4, the requirements of belonging and being in use, both before and after. My submission is they're not there in subsection 1. Now, there might be, I suspect HMRC would say that the belonging one is there, impliedly, or is assumed, or something like that, but in any event, it's perfectly clear that it's not there expressly. When we come on to section 78.1, we'll see there's also a requirement relating to use before and afterwards, but not a requirement express relating to belonging.
But there are also differences in the definition of connected person, or are they the same? Don't look at it the same.
Well,
one looks at only the section 839, and subsection 5 looks at it's a broader definition.
that might be another one, yes.
But there must somewhere be a definition of connected with for the purposes of subsection 3.
Oh, well, it's subsection 5.
Oh, sorry, yes. Very true. I'm not wanting to get us involved in areas that don't matter from the point of view of this case, but I'm just trying to understand, since clearly a point is made by you about the about subsection 4A. Why, as a matter of history, the draftsman had different provisions before and after the 88 Act. Are these provisions taken from the 88 Act and put into the
Yes, so that the previous legislation was amended by the 88 Act. And the 90 Act comes along as a consolidation act.
Yes.
And wants to make clear that there are differences according to the time of the succession. But obviously, the legislation itself doesn't explain why Parliament decided to impose these express conditions going forward, as it were.
No, you'd have to look at the 88 Act and see why this new regime, this slightly different regime, you say not that different, but nevertheless different enough to require
we have
new
looked.
provisions.
I mean, both sides have done a lot of trawling through past legislation, and we haven't found anything that casts light on specifically why Parliament decided to, as it were, tighten up the rules going forward. I'm not saying that Mr. Gibbon's done it, but we on our side have definitely done it, obviously to see if it helps or hurts us.
Yeah. Okay. Well, in the end, submissions may or may not be made about it, but I'm just trying to understand what happened. So what happened is, just make sure I've understood it correctly, the 88 Act tightened up the regime going forward by introducing the provisions which we now see at 3 to 8.
Yes.
And one of the differences is the one you draw attention to.
Yes, but I mean, I simply make this point. Parliament did not take the opportunity in any event to tighten up Section 78(1) or to make it express what wasn't expressed. That's clear. So that the Finance Act 88 did not make any amendments to Section 78(1). What it does say in subsection 8 is that Section 78(1) shall not apply in a case where an election is made under subsection 3.
Sorry,
just looking at subsection 8, I'm just saying the draftsman was aware of Section 78(1) when he enacted the tightened up Section 77.
But presumably the predecessor of Section 78(1) existed prior to the 1988 Act.
Yes. And there's one other succession provision I wanted to take you to, just to show you the same general object of tax neutrality, as it were, where there is a succession. And that's in tab 10. And this is section 155 on page 121. And in order to explain, I need to go back to, first of all, section 153. If I can just give a very simple example. And I can give it by reference to a slightly amended version of the facts of our case.
I'm so sorry, I missed your intro. What's the overall thing you're seeking to establish by this
Another
exercise?
example of how a succession is given, as it were, special treatment, so that the successor to the tray qualifies for allowances, albeit only writing down allowances.
Thank you.
And I was going to explain, this is in section 155, but in order to explain it, because 155(1) says, it has effect where 154 applies, and you can only understand 154 by reference to 153. So if I can just give a simple example, and I'll be as quick as I can. By reference to the facts of our case, except that suppose that instead of its IMSO contracting for the launch costs, which it did itself, suppose that the lessor had bought the satellites and itself contracted for the launch costs, but IMSO had agreed to reimburse the lessor the launch costs. So if you... Now, what 153 says, that effectively, if expenditure is subsidised by someone else, you don't get allowances for it. That's 153.1. And then 154 says, but the person who makes the contribution can get allowances. And the way that works, if you look at 154.1 first of all, where the person for the purpose of a trade carried on by him contributes a capital sum to expenditure on the provision of an asset, being expenditure which, apart from 153, would have been regarded as incurred by another person. In this case, it would be regarded as incurred by the lessor. And then don't worry about parts 1, 4, and 5, because we'll see that 154.2 deals with subsection 2. Such initial allowances and writing down allowances shall be made to the contributor as would have been made to him if his contribution had been expenditure on the provision for the purposes of the trade of a similar asset. But then what 152 says, this is now for the purposes of part 2, which is machinery and plant allowances.
So what, 152?
154.2, subsection 2. Subsection 1 shall have effect as if, A, the reference to expenditure in respect to which allowance would have been made under part 1 include a reference to part 2. And B, the reference to the making to the contributor to expenditure on the provision of an asset, and so on, if his contribution had been expenditure on the provision of a similar asset, included a references to being treated under part 2 as if his contribution had been expenditure on the provision of that asset. So, sorry this is a big mouthful, but what all that's saying is the contributor, for the purposes of part 2, machinery and plant allowances, is deemed to have incurred expenditure on the provision of that asset, the asset which actually belongs, or is treated as belonging, to the person who actually incurred the expenditure but doesn't get allowances on it, the lessor in my example. So reading on, and for the purpose of an allowance under part 2, that asset should be treated as belonging to the person making the contribution in respect to which the allowance is given, at any time when it belongs or is treated under part 2 as belonging to the recipient of the contribution. So the lessor, the recipient of the contribution, for so long as the asset belongs or is treated as belonging to the lessor, the recipient, it's deemed, the same asset is deemed to belong to the lessee, the contributor. And that's how the contributor gets allowances, even though the contributor hasn't actually incurred expenditure on provision. He's made a contribution to someone else's expenditure. That someone else doesn't get allowances. The contributor does, and the way it's worked is by deeming the contributor to satisfy both of the expenditure and belonging conditions. But the particular belonging condition is that it belongs to the contributor for so long as it belongs or is treated as belonging to the recipient of the contribution. So there you have an example. We'll be coming back to this when we look at section 61.4 of what's called deemed multiple ownership of the same asset.
So two deeming provisions, but and where you end up conceptually is where, on your example, as the lessor and lessee both having a right to these allowances, depending on what they've actually put in.
Yes, they both have the right, and to get there, you need to deem the asset to belong to both of them.
Yeah.
Not so as you boggle and say, my God, how on earth can this asset belong to both of them? It's a deeming for a particular purpose, to enable both of them to qualify for allowances. Right, well, that's 154, and then the question is, so we've got this recipient who's qualifying for the contributor, who's qualifying for allowances in his own right. But then there's a succession to the contributor's trade. This is 155, subsection 3. Where, when the contribution was made, the trade for the purposes of which it was made was carried on or to be carried on by the contributor. the following provisions shall have effect on any transfer of the trade. A, where the transfer is of the whole trade, writing down allowances for chargeable periods ending after the date of transfer shall be made to the transferee and not shall be made to the transferor. So that's my only point. This is another example of a succession, a transfer of a trade. The transferee has not incurred any expenditure. The machinery or plant clearly does not actually belong to him. But he qualifies, the transferee qualifies for allowances in his own right. He steps into the shoes of the transferor who did incur the expenditure. So I've given you some examples of successions to trades in section 77(1).
Is there a definition of a transfer of the trade?
No. It's just general principles, as it were, of what's involved. So clearly there are requirements there, but there's nothing in terms of ownership of the plant that the contributor can transfer, because the contributor is only deemed to own under section 154 of the plant. So there cannot be any transfer of the asset. Well, now can I take you to section 78, which is on the next, on tab 9, page 110. We're only looking at the moment at subsection 1. We'll come on to subsection 2 later, because HMRC rely on that. Where a person succeeds to any trade, which until that time was carried on by another person, so that's the first requirement, that there's a succession to a trade, and it's common ground that that was satisfied here. And by virtue of section 113 or 337 of the Principal Act, changes in persons carrying on a trade and special rules for corporation tax, the trade is to be treated as discontinued. I don't think I need to take you to 337. It's common ground that 337 operated here when IMSO ceased trading, transferred its trade to Inmarsat. That's common ground that that condition was satisfied.
I wouldn't mind just seeing it at some point.
Yeah,
No,
no, I'll do that now, because
Yeah.
if you want to see it, then... I think we have to go back to tab 8. Section 113 is on page 30. So, subsection 1, where there's a change in the persons engaged in carrying on any trade, profession or vocation, then subject to and so on.
So what would be a paradigm case? I mean, would this bite where there's a change in the constitution of a partnership, or
well, there are special
rules about that?
There are special
naturally.
rules, I'm afraid, about partnerships. But if we just keep it simple, as it were, and have a sole trader who transfers their trade to somebody else,
Sells it.
it could be sells the trade, could be, in any event, the trade is transferred by whether consideration or not.
But if it's a sale, it's not within section 78 anyway.
No, sorry. In terms of section 78, no. If they could sell the trade but not the property, I suppose, so that could still fall within section 78(1), because section 78(1) is focusing on whether the property is sold, the property really being the relevant property for capital allowance purposes. But if we keep it simple, there's just a transfer of the trade.
I'm just trying to think of real life situations. We are not, for the reason given by my lord, for the purpose of section 78, concerned with a sale.
No.
So, a gift of a trade that dad gives it, parent gives it to child.
Yeah. That would be a case where there isn't a sale, clearly. One of the points I make in my skeleton argument, which I submit is a good point, is that actually won't make any difference than the position under section 78(1), because there is a provision in the 1990 Act which deals with gifts and says that if there's a gift of plant, then the donee is treated as incurring capital expenditure equal to market value. So that 78.1 clearly, I would suggest, is not thinking that it's a gift. One of the points I make in my skeleton argument is that if Section 78.1 is not dealing with, is not deeming there to be a transfer, in the sense of not deeming the successor to become the owner, and is only dealing with valuation, there is actually a very, very limited scope that Section 78.1 has. And the legislation that was handed up as tab 46 this morning was intended by HMRC to be an answer to that. I'll come on to that, but it actually raises more difficulties than it answers, as I will explain, but I won't muddle things up now. But in any event, if my submission is that a prime function of Section 78.1 is to put the successor into the predecessor's shoes by fulfilling both of the expenditure and the belonging conditions.
Yes, I'm still interested, maybe my lord is too, on just actual factual scenarios where Section 113 viewed it by itself can cover all sorts of situations, it's extremely general.
Right.
Changing partnership, perhaps, and you say that's subject to separate provision, but sale, gift, oddities like transfer by operation of statute.
Yep. It could be a trade is succeeded to without any property. I mean, if you want to keep it simple, then that obviously wouldn't be a case. But you could have a case where the machinery or plant used in the predecessor's trade continues to belong to the predecessor, but the trade continues in the hand of the successor who uses the plant.
Yes, you gave that example, or it could be a business trade which has very little
Property.
Very little plant indeed, and you can carry on the trade without using the plant. Anyway, I see. So that Section 113 is very general.
That's what.
But the more difficult question then, which is really what my lord was saying, which is what interests you and ultimately must interest us, is Section 113 cases that are not sales and not gifts, because both of those are separate. Sales are excluded, and gifts are subject to separate provision.
Yes.
So you've got the cases, you say, where there's a succession to the trade but without property. What other situation would be within Section 78?
Where Section 78 would apply.
Yes. So we assume that it's not a sale, not on the face of it gift, because that's provided for elsewhere, and not partnership. So what are we dealing with?
Well, if I'm wrong, or leave aside my point that it deals with the case where the property isn't transferred, but wants to make sure the successor gets allowances, so says there's a sale to him, he becomes the owner. Leaving that aside, if you look at a case where the successor does actually own the property, then what cases would it apply to? Well, as we've seen, it doesn't apply to a sale. And sale, I say in my skeleton argument, has an extended meaning under the Act. It includes a case where there's an exchange of property. So...
Okay, but that's an unusual situation, but it could happen, yes.
It says expressly, any exchange of property is also deemed to be a sale. So it can't be an exchange of property. It would have to be, let's say, for consideration in the form of, let's say, a service. So HMRC give an example in their skeleton of where an employer gives a bonus to his employee by transferring a trade to him. That's a fairly unlikely that the legislation was focusing on that, I would submit. Another example is where it's by operation of law.
So if the consideration is a service, that is not a sale. For this
That
purpose.
wouldn't be a sale because it wouldn't be an exchange of property. Or it could be that it's not a gift, but it's not for consideration, like a operation of law. And I mentioned in my skeleton, I'm sorry to complicate things, but there is special legislation, I haven't taken you to 337 yet, and I will do, but Section 343 says there isn't a permanent discontinuance or a deemed one if there's a transfer of a trade between members of the same group. So that you might say, well, if it goes from one subsidiary to another subsidiary in the group, that isn't a gift, may not be a sale, but that's out anyway. That can't be within Section 78.1. So my point is, if we leave out from the operation of Section 78.1 the case where the successor doesn't become the owner, if that's not covered by 78.1, then actually 78.1 is doing very, very little work indeed.
In what sorts of cases would a trade be transferred by operation of law? We've got one here of a rather particular nature, but I'm getting very out of my depth here, but my lord will take pity on me. In any sort of insolvency situation?
Well,
Bankruptcy, but not company insolvency.
well, if I can address bankruptcy, not insolvent, not corporate insolvency, that's the legislation which has been handed up today by HMRC, the bankruptcy situation. And if you wouldn't mind me just addressing that now that you've asked about it, because if you remember, and the legislation is there in tab 46, the bankruptcy estate vests automatically in the trustee in bankruptcy immediately upon the trustee's appointment. So there's a transfer by operation of law of the property at that moment. And then the legislation goes on and says that the trustee in bankruptcy has various powers, including a power to carry on the bankrupt's trade, but that requires the consent of either the creditors' committee or the court. So that's something that's going to follow, if at all, after the appointment of the trustee in bankruptcy, by definition. So you get, first of all, the transfer of the property, and then maybe, subsequently, you get a succession to the trade. And the question is that within section 78.1? Because HMRC say at various points in their skeleton, they refer to some sort of connection between the transfer of the property and the succession. But they're all, for example, in their skeleton, they say that 78.1 is dealing with the case where the transfer results from the succession. Well, that isn't the insolvency case, the bankruptcy case. The transfer doesn't result from the succession. The transfer happens anyway, and there may be a succession afterwards. So I will come back to that point, because HMRC's case...
You said the transfer happens anyway. What?
The transfer happens irrespective of any succession to the trade.
Is that a possible characterisation? I mean, I follow the trustee, if he wants to carry on the trade, has to get consent.
Yeah.
But is that not consent to carry on a trade that has already passed to him? I mean, the
Yeah.
goodwill must have gone to him.
And the plant.
Another power of the trustee is to allow the bankrupt to continue trading, and that often is the case. That the bankrupt doesn't carry on trading as nominee for the trustee.
What is that? Is that right?
Mr. Gibbon disagrees with me there.
Well, I know nothing about insolvency, but I'd have thought that can't be right. It must be.
Clearly,
If the property has passed to the trustee, but the bankruptcy is allowed to continue to trade, the bankruptcy must, in some sense, be doing so on behalf. The bankrupt must be doing so on behalf of the trustee, mustn't they?
Well, in the sense that all of the profits belong to the trustee, absolutely.
What about administration? Is a red herring here, is it?
It is because
Because the company will continue to have the trade.
That's what I assumed. But yes, okay. Okay, so it's so. I'm just exploring. It looks just in the big picture here. It is in your forensic interest to say you can't say Section 78 would have no scope at all.
No, I can't go that far.
On the HMRC's case, but you say it's a very limited scope, and you've given us the example of where they require the trade but not the plant. And then you've also accepted in principle operation of law.
I do.
And that's what we're on now, bankruptcy and...
Yeah. Operation of law often, I mean, if you have nationalisations or whatever, the legislation often deals expressly in one of the schedules with the tax consequences, including the capital allowances consequences, because those are special cases. So in my submission, it's unlikely that Parliament, when enacting Section 78.1, was dealing with something along those lines.
And just help me on one more thing. Suppose you have what is not that uncommon, a one-man business or business being carried on in partnership, and then a company is incorporated to take over the business. How does that work?
That is dealt with by Section 337.
Yes, I see. And that could be within Section 78?
Well, if I can just take you to 337. So 3371 is dealing with deems there to be a discontinuance, whether or not the trade is in fact.
I have to say, just reading this, I wasn't quite clear what it did mean.
Right.
In the sense that if it says where a company ceases to carry on a trade, the company's income shall be computed as if there is a discontinuance, whether or not there is in fact a discontinuance. But if the company has ceased to carry on the trade, why isn't there a discontinuance?
Because the company has discontinued, but the trade itself.
I see, a discontinuance of the trade. Yes, I follow. In fact, it's perfectly obvious. Yes.
And then if I could just take you to 343, there's 2 pages on. That's to do with one company ceasing to carry on the trade and another company beginning to carry it on.
I'm being slow. Why is this an answer to my Lord's initial point about the transfer of an unincorporated business to an incorporated business with the same?
That doesn't answer it. I was about to say that. That doesn't answer it.
Neither 337 nor 343.
No.
Well, so.
Oh, sorry, 337 does.
Yeah. Okay. Why?
Because it applies where a company begins to carry on the trade.
Yes.
Well, I suppose the answer is if we're looking at an individual who ceases trading, that's 113. So that's a deemed discontinuance of the individual's trade. So that would be within section 78.1. That would, where there's an incorporation of the individual's business. That could be within 78.1, but only on HMRC's case if the property passes as well.
Yeah. Well, that. My Lord says that's not an uncommon situation. It's not a gift, I suppose. Nobody would say it was a gift to the company.
If it were in return for shares, the problem is that would be in exchange for property, and that's deemed to be a sale.
Well,
So
it
you
would
have
be
to-
in return for shares, wouldn't it? Is
Well,
that,
it would normally be. It would be incorporation.
yes.
But that would be a deemed sale because it's in exchange for property, which is a deemed sale.
So are you saying, I mean, eventually we got to the point where actually you're saying in the classic situation, this isn't called by section 78?
Sorry, I'm going a bit more slowly than you are, and I apologise for that. But yes, I am saying that classic situation would not be within section 78 because that would be a sale.
And if, on the other hand, it were a father generously allowing his son to take over the business in a corporate form, that might be a gift, I suppose.
That might be a gift. Well, that would be a gift in my submission. If there's a donative intent, that would be a gift.
Yep.
So, if we go back to tab 9 and section 78, on page. I ought to take you to the gift provision, I suppose, because I've been talking about it. That's on page 112, section 81. 81.1.
Oops.
Bottom of the page, where a person B brings into use for the purpose of a trade carried on by him machinery or plant which belongs to him in consequence of a
So sorry, I'm behind you. Which page?
Page 112.
Yes.
This is section 81 at the bottom. 81.1b.
Sorry, I've made a note earlier of the gift provision, section 90. So it's wrong.
I know. If I said that, I would mistake.
No, that's fine. It's probably me. Okay, thank you.
81.1b brings into use for the purpose of a trade carried on by him machinery or plant which belongs to him in consequence of a disposition by way of gift. Sections 24 to 26 shall have effects if that person had incurred capital expenditure on the provision of the machinery or plant for the purpose of the trade. The amount of that expenditure being taken as the price which the machinery or plant would have fetched if sold in the open market. The machinery or plant being treated as belonging to that person in consequence of his having incurred that expenditure. So that, in my submission, is a particular provision dealing with gifts, and section 78 does nothing there. It doesn't change the position of the successor at all. One of my submissions will also be, I'll develop this, is that section 78.1 says nothing about the predecessor. It only says something about the successor. But if it's a gift, it says nothing. It doesn't alter the effect. It doesn't make any difference to the successor because 81(1)(b has done that already. Now, in section 78(1), we've got to the reference to sections 113 and 337. And it was common ground that that applies here. That express condition is satisfied. The trade is to be treated as discontinued. Then any property which, immediately before the succession takes place, was either in use or provided and available for use for the purposes of the discontinued trade. Stopping there was such property which was, in fact, in use, namely the satellites. And without being sold, stopping there, the satellites were not sold, is immediately after the succession takes place, either in use or provided and available for use for the purposes of the new trade. Yes, the satellites were in use for the purposes of Inmarsat's trade. Shall, that's the property, shall be treated. This is not treating a particular person, this is treating the property as if it had been sold to the successor when the succession takes place. That's A. And B, the net proceeds of the sale had been the price which that property would have fetched if sold in the open market. But no first-year allowance shall be made by virtue of this subsection. Now, my submission is that A, and those paragraphs A and B are doing two things. A is dealing with the ownership of the property. It had been sold to the successor when the succession takes place. And then referring to those two cases I mentioned, Crossman and Lionel, were to do with inheritance tax and estate duty and so on. The meaning of sold to the successor is the successor becomes the owner, the absolute owner. And then B is dealing with expenditure. Now, it's true that B is in terms of the net proceeds of the sale, and I'll come back to that point if I may, but in any event, it's common ground that B has the effect, where it operates, that the successor is deemed to incur capital expenditure equal to the market value of the property. And that's absolutely clear when you see the words, but no first-year allowance shall be made by virtue of this subsection. It's by virtue of this subsection that allowances are made available, but the draftsman says, but no first-year allowances. Why no first-year allowances? Well, I would submit that's relatively clear. It's because this is property, machinery or plant, which has already been in use. This is not new plant in the hands of the successor. Obviously, from the successor's point of view, it is. But it isn't new plant, it's a continuing trade, it's already been in use, and therefore first-year allowances should not be available, but writing down allowances should be available. Now, HMRC say, well, what
Sorry, have you shown us where Section 24 provide for first-year allowances?
No, it's Section 22, but
you haven't
it's
shown us
also
that
in
yet. No, that's fine.
I hadn't done.
I was just getting it all clear in my head.
Back on page 37 is first-year allowances. And by the time we get to 1999, first-year allowances are quite restricted. You see the heading there in section 22 on page 37. Transitional relief for regional projects. And there are various other exceptions. But generally, it's writing down allowances only that you get. But the point is, when this legislation was enacted, section 78(1), first-year allowances had a wider scope. But the draftsman didn't want first-year allowances to be available to the successor for the reason I've given in my submission.
Hang on 1 second. I'm sorry to take you off your point,
Right.
but at some point we're going to be told, and we are told in the skeletons, but I haven't internalised it, where Section 78 originated but it's many years before 1990.
1945.
Yes, that's what I thought I remembered. At that point, were first-year allowances more significant than they are now?
Yes, they were then called initial allowances, and that was what the legislation said, and they were more significant.
Thank you.
But it's the words shall be made by virtue of this subsection that makes it absolutely clear that allowances are made by virtue of this subsection. And obviously the dispute is, are they only made if in fact the property belongs to the successor, or are they made by virtue of the operation of A and B, which deems, where it wouldn't otherwise be the case, the property to belong to the successor? That A and B do that double job, as it were.
Can I just
Yes.
press that through,
Yes.
just to make sure that I've got it?
Of course.
So, your case is section 78(1), you read that through, and then the fiction you get to at A and B. Treatment is as if which is what the trade, had been sold to the successor when the
I'm sorry, it is the property, not the trade.
Property had been sold to the successor when the succession takes place, and you say such that the successor, the property now belongs to the successor, and you say that's the natural consequence of the word sale. So that's the belonging condition.
I go a little bit further and say that's the meaning of the word.
Okay, but that's what I need to not. I'm trying to avoid words like reading in, but you know where I'm heading is just that's what you mean by it.
Yes.
Okay, what you say it means.
Yes.
So that fulfills the belonging condition.
Yeah.
So it's the other way around from how you see it in section 24.
Yeah.
And then B, when it talks about the treatment as if the net proceeds of sale have been the price which that property would have fetched if sold in the open market, you say that you need to understand from that and that the successor had incurred that expenditure, i.e. the net proceeds of sale, on buying that property.
Yes, had incurred the price.
Yes.
So it's an odd use of language, I accept. And it looks like you're focusing
price.
on. It looks like you're focusing on the predecessor by referring to the proceeds.
Yeah.
But
you say properly construed. What this is telling you is that the successor is to be treated as having incurred that price.
Exactly, and that is common ground.
Okay.
That is common ground where Section 78(1) operates. And the issue is, does it only?
But it's not common ground for this appeal, is it? Because that's the point.
Sorry,
of the case,
I've been slower than my lady. In what sense is it common ground?
That where Section 78(1) operates. So in the case where HMRC accepted operates, where the property actually belongs to the successor, the effect of B, well, A and B together, HMRC say, is that the successor qualifies for writing down allowances on an amount equal to the market value of the plant. That those words, the net proceeds had been the price, must be interpreted from the point of view of the successor as meaning, having the effect that the successor has incurred capital expenditure equal to that price.
I see. I hadn't appreciated that HMRC accepted that.
Yes. But I emphasise they accept it only if what they say, the assumption made by Section 78(1) is that the successor actually becomes the owner. If that assumption is false, HMRC is saying...
No, I get that entirely, and that's important, but it is still helpful to you as an answer to the point, this isn't intended to have anything to do with the successor, because why use language net proceeds of sale, which is so obviously directed at the predecessor? You haven't had a chance to say everything you have to say about that, but you say, well, you agree it is a bit odd.
Yeah.
You may have more to say about that in a minute, but odd as it may be, it's actually not contentious in some cases.
Yes, exactly. Yes. So the words have to be construed, as it were, from the point of view of the successor. Now, in my skeleton argument, I go from trying to explain what the as it were, the preconditions for the operation of Section 78.1 were. One of which we accept is ownership or deemed ownership by the predecessor. I then try and make that good in our case by going to 61.4. I think the way that this is going, it will be simpler if I stick with all my submissions on 78.1 now, and then come back to 61.4 later this afternoon, if that makes sense to you.
Certainly. It does to you.
Yeah, that's fine.
But it means that I'm not going in the order in my skeleton. I apologise for that. So that, let me explain why Inmarsat accepts that the plant must belong or be deemed to belong to the predecessor in order for Section 78.1 to operate. Well, there are two reasons. The first is the property shall be treated as if it had been sold to the successor. One can't postulate, it's obviously it's being sold by the predecessor. It's not sort of sold in the abstract. One can't postulate a sale of something one doesn't own. So my first point is the language assumes that there is something belonging to the predecessor or deemed to belong to the predecessor. But that's the language. More important is the policy behind Section 78.1 in my submission, which it's all about recognising that this deemed discontinuance of the trade, and 78.1 only applies if there is that deemed discontinuance under 113 or 337. That deemed discontinuance of the predecessor's trade is a disposal event for the predecessor. I took you to section 24 and 26 to see that a permanent discontinuance, or one that's treated as a permanent discontinuance, is a disposal event, and the disposal value is market value. Section 78.1 knows that that's the rule and wants to ensure that because the trade is continuing, the successor will, in a broad sense, step into the predecessor's shoes and qualify for allowances. But of course, that disposal event and that disposal value only occurs. One of the conditions for there to be a disposal event in a chargeable period of a trader is that the plant belongs to them in the chargeable period. And a permanent discontinuance is only a disposal event if that's the first event to occur. Other possible events are ceasing to belong. So a disposal event consisting of a permanent discontinuance presupposes that the plant is at that point belonging to the predecessor. Now, the draftsman of 78.1 in my submission knows all about that and knows, therefore, that the sort of paradigm case is, here we have plant that belongs to the predecessor, there's a deemed discontinuance of the trade, what's the position of the successor? And the draftsman wants to ensure that the successor qualifies for allowances on the remaining value, the remaining market value. And the way that's achieved is by those paragraphs A and B. But all that presupposes is there is a disposal event for the predecessor, in principle. That's, as I put it in the paradigm case, that's the sort of basic working assumption, as it were, of Section 7.1, which would only be the case if there is something belonging to the predecessor. And that's reflected in the language of treating the property as being sold.
Can I just understand it by reference to one of your examples?
Yeah.
Suppose you have a case where somebody is carrying on business, and for the purposes of that business, he has some property. And then he transfers the goodwill that keeps the property for himself, on the basis, presumably, that the successor pays him for the use of it? Or?
It could be.
Yeah.
It could be, or for some reason they don't get round to making a transfer then, or until much later, or something like that. It could be that it's leased or, yes, hired out or something.
Well, I don't think this helps or complicates it, but there are some sorts of businesses where you would sell the goodwill, but the purchaser could replace the plant with plant maybe that he already had, or that he bought and chose not to buy the plant that serviced the trade from the seller. That quite a common situation as well, wouldn't it?
It could be a common situation where the purchaser doesn't purchase the plant, but takes it over and then replaces it as time goes on. But in terms of the plant that's in place at the time of succession, the question is, although there's no transfer of that plant, does the successor qualify, step into the shoes of the predecessor?
And just to understand it a stage further, in that situation, why should the successor have the benefit of the allowances?
Oh.
He's taken over the trade, he hasn't taken over the property.
Well, he's taken over use of the property. And the important point in my submission is this legislation is there to encourage the incurring of expenditure on plant, let's say, for use in a trade. That has happened. Thereafter, yes, there's a deemed discontinuance, but the trade continues in someone else's hands. We've seen various succession provisions that clearly put the successor into a position where he or she can claim allowances despite not incurring any expenditure. And in section 155, despite clearly not owning anything, the broad policy in my submission is it shouldn't matter that there's a deemed discontinuance of the trade. It shouldn't matter that somebody else takes it over. The important point is allowances are still available, the plant still has some value, and it's still being used in the continuing trade. That's the thinking behind all those succession provisions, and in my submission, the thinking behind section 78.1. I mean, it's undoubted that the focus of 78.1 is a succession which is deemed to be a discontinuance of the trade. So it's focusing on that particular event. And one asks, why should it focus on that event? Why focus on the fact that there has to be a deemed discontinuance, even though the trade continues? And the answer is in my submission, because the draftsman knows full well that that is a disposal event for the predecessor. And he wants to do something for the successor to, as it were, make it tax neutral.
So just taking it a stage further for a moment. So suppose your case of somebody selling the business but keeping the property. Assume for the moment that section 78 doesn't bite.
Does or doesn't?
Doesn't.
Doesn't.
Assume that HMRC are right, it doesn't bite.
Yeah.
How does it work then? The seller of the business keeping the property, there's been a disposal event, but he hasn't sold the property for anything.
No. So that let's assume that the depreciation of the plant works parallel with the getting of allowances.
Yes.
So that it was originally bought for 100, it's now worth 50, and the predecessor
Yes.
has claimed allowances of 50. The permanent discontinuance of the trade, the deemed permanent discontinuance, although there's no sale, is a disposal event.
Yes.
For market value. So the predecessor has to bring in that 50,
Yes.
which equals his remaining qualifying expenditure.
Yes.
And there are no further allowances available.
And then the question is, should the person who hasn't acquired the property get the benefit of the allowances that the person who still has the property
Yes.
would have had?
Well, my submission is that we've seen, I mentioned that there are deeming provisions that deem property to belong to someone, and we'll go on to section 61.4, which is one. Parliament is more concerned, I would submit, about giving allowances for capital expenditure than being totally obsessed with there being actual ownership. That's why those deeming provisions are there. In certain cases, which as it were appeal to Parliament, good policy reasons for saying, although this doesn't actually belong to you, because expenditure has been incurred, we want allowances to be available. And the good policy reason here is that there's a succession, that the trade continues and the plant is still in use in the trade, or available for use in the trade. That's the reason for wanting allowances to continue, even though the successor hasn't incurred any expenditure and it doesn't belong to him.
I mean, what's a bit odd is I can quite see why the original investor needs to be incentivised. So you would think that when he wants to sell his business, he should potentially get the benefit of the fact that he's invested. And he'll get that if he sells because although he has to bring into account the disposal value, the purchaser will get allowances based on what
Because
he
he buys it.
paid for the goods or the plant, and that doubtless has an impact on what the original investor can sell it for. But if the original investor isn't selling the goods, well, does the same logic apply?
Clearly, on any view, where there isn't a sale and the successor has not incurred any expenditure, we know it's common ground that if Section 78 operates, it operates to deem him to incur expenditure. So the question is, why should everything turn on whether the successor is actually the owner of the plant as well? Why should everything turn on that? If you've had expenditure incurred on the plant and it continues to be used in the trade, and you've still got, as it were, value that hasn't attracted allowances, my submission is that there is a fairly clear policy reason for allowing that property to continue to attract allowances, even though it doesn't actually belong to the successor, because he's carrying on the trade.
But he wouldn't have incentivised the original investor.
Well, it could conceivably incentivise a continuation of the trade if the successor knows. Otherwise, you might as well wind the trade up.
But I'm having difficulty understanding the example in commercial terms. I can understand that's why I now see a slightly off the point intervention about a situation in which you sell the goodwill but don't sell the plant, and the plant isn't even used because the purchaser provides his own plant. But what I think my Lord is exploring with you is a situation where the goodwill, the trade is sold, the business is sold in one sense, but actually the plant is not sold.
Retained.
But is retained for use in the business. But in those circumstances, the seller, in all ordinary, would require some other reward for continuing to allow their plant to be used in the business. He might charge a rental, or it might, I suppose, be built into the price in some way that reflected the fact that the person was getting the use of the.
Let's assume it's leased, to the successor.
Well, I rather leave out. All right, could be leased to the successor. Yes, it's essentially what I. Sorry, yes, exactly. I suppose that is a possible scenario. I'm probably just behind the two of you, but in those circumstances, the original investor will have made his. He won't be able to foresee what will have happened, but he will still be getting value off his plant, or will presumably be carrying out a trade as a lessor of plant. Won't he be claiming capital allowances for that trade?
It's possible, I suppose, if it's there are provisions dealing with, first of all, leasing trade.
Well, that's why I'm trying to understand this how this example would work in the real world. It's hard to imagine a situation in which the vendor goes on allowing the plant, which he retains the title, to be used by the buyer, but with no reward.
Well,
Form of the reward maybe it could be a lease is the most obvious one. You could think of other ways in which it
let's
could be
assume
done.
it's a lease. The position is, nevertheless, that because there's been a permanent discontinuance of that trade, of the trade carried on hitherto by the predecessor, that all of his remaining qualifying expenditure has been matched by a disposal value. He's got no allowances. He's no qualifying expenditure left, which he can then say, oh, I want to get allowances for on my leasing trade. There is nothing left. So that, as far as the predecessor goes, that's it as far as allowances go, even though there's still remaining value in the plant. If one looks at the question of incentivization, it might be difficult to imagine that someone is incentivized to carry on a trade knowing that if he ever decides to cease it, allowances could continue in the hands of a successor. But it's a bit easier, perhaps, to imagine that if one's considering whether the trade should continue, that you're more willing to allow somebody else to carry on the trade, other things being equal, given that you know that you can say to them, allowances will be available for this plant. They won't be available to me because I've been matched with a disposal value. But in other words, one can see it making sense to have a transfer of the trade, for the trade to continue. If that otherwise,
in fact, didn't you give up more than you needed by saying that you can see that it's no interest to you if you foresee that you may sell on and not get any incentives, but the fact that the purchaser will get, the fact that the purchaser will get allowances will, as my lord said earlier, almost certainly be built into the purchase price if they're valuable.
So it's built into the rent. So there is an incentive for the predecessor if he's going to rent it, not in terms of allowances because he doesn't get any more allowances, but in terms of the rent that he can charge because the successor is going to qualify for allowances, and that will be built maybe into the agreed rental. So maybe the answer is one is incentivized to purchase a plant knowing that one can get allowances for so long as one trades, but they don't cease necessarily when one ceases trading, or rather the benefit of them doesn't cease altogether. They continue in the hands of the successor, and that may be to the commercial benefit of the predecessor. I'm not sure that Section 78(1) had all those points in mind, but certainly it's not as if it sort of doesn't make any sense for Section 78(1) to operate in the way I've submitted. So I've just got a few points left on Section 78(1), which I hope to make by 1 o'clock, and then in the afternoon, if I may, I want to turn to 61(4). So I think I made my first point already one way or another about Section 78(1), which is it's perfectly clear that there's no express provision that the property must actually belong to the successor. And that's a contrast with Section 77(4). The draftsman of Section 77(4) did not take the opportunity to make 78 turn it from an assumption, as HMRC put it, into an express condition. But Section 78(1) does have express requirements about use. As we can see, it must be in use or provided and available for use before and afterwards. That's what 78(1) says. So one asks, why would the draftsman go out of his or her way to have an express requirement of use, relating to use, but then leave it to a sort of an implied assumption that there must also be a transfer of ownership? And I've also made my next point, which is that I submit that the natural meaning of the words, it had been sold, the property shall be treated as if it had been sold to the successor. The natural meaning of those words is that passes absolute ownership to the successor.
I think you'd accept with me, Mr. Prosser, that if this is what the draftsman wanted to do on your analysis, that there'd be like 100 different ways of doing it more easily than here. I mean, it would have been a fairly straightforward drafting exercise if the draftsman had wanted to say A equates to the belonging condition and B equates to the expenditure condition under Section 24. I mean, it could have been quite easy to have made a cross-reference.
I accept that. I mean, there are so many different ways in which one goes through Part 2.
Yeah.
And the different way. I mean, let me just give one example. I took you a moment ago to Section 81(1), which went out of its way to say the amount of that expenditure being taken as the price, so on and so forth, and the machinery or plant being treated as belonging to that person in consequence of his having incurred that expenditure. Because, of course, that's another requirement of Section 24. We know that 78.1 doesn't do that.
No.
It doesn't tell you that it belongs in consequence. You have to spell that out.
Yeah.
So the draftsman could have done a better job,
Right.
in my submission. I think that's probably shared on both sides. Otherwise, well, if he'd done a better job, I wouldn't be here, certainly. But the fact that he could have done a better job, and then one's got to sort of scratch around to get the true meaning and purpose, I would submit does not count against me. That one is still obliged to identify that purpose, and on any view, one of the purposes is to deem the successor to have incurred expenditure, even though that's not well drafted. So he could have done a better job, yes, I accept. Well, I've made the next point as well about what implications one draws from the reference to sale and net proceeds. I think I've made that point. That it would be wrong to infer from that this is all about the position of the predecessor. Because that's absolutely clear, not only is it common ground, but it's absolutely clear from those closing words about allowances being made by virtue of this subsection.
Are you going to deal with Mr. Gibbons' point that those closing words would be equally necessary on his interpretation?
Oh, I accept that if he's right, and that Section 78.1 does contain an assumption about belonging on the part of the successor, that those words still have a role to play, absolutely. The point I was making...
Doesn't that completely neutralise the point?
No. I think that the point I was making, which is really a response, I'm not suggesting that those words show that I'm right about belonging. What the purpose of me taking you to those words is that it would be wrong to think that because of the reference to sale and net proceeds, that 78.1 is all just about looking at it from the predecessor's point of view. Because one of the points made by the upper tribunal is that the natural reading of these words is it's all about the predecessor and not about the successor. And I would submit that's wrong. The words at the end show that it's not all about the predecessor and not about the successor. And then my next point is actually it's not about the predecessor at all. And the reason it's not about the predecessor is because 78.1 makes not a jot of difference to the position of the predecessor. Because we've already seen, when I took you to sections 24 and 26, that when there's a deemed permanent discontinuance of the predecessor's trade, there is a disposal event, and the disposal value is the market value of the plant. So by deeming the property to be sold for a price which it would have fetched if sold in the open market, is repeating the words in 26.1f. Now, in other words, we're not changing the position of the predecessor at all by deeming the predecessor to sell the plant. And that is an indication in my submission that actually the true focus of 78.1 is on the successor, not on the predecessor. Now, in response to that point, HMRC say, well, look at 78.2. If I can take you to 78.2. 78.2 deals with the position where there's a succession to a trade as a beneficiary under the will or on the intestacy of a deceased person. So that's the particular circumstances. And there's an election. Then in relation to any machinery or plant which passes to him together with the trade, being machinery or plant previously owned by the deceased, and either used or provided and available for use by him for the purposes of that. The reference in subsection 1 to the price which the machinery or plant would have fetched if sold in the open market shall, in relation to the succession and any previous succession occurring on or after the death, be deemed to be a reference to that price, or if it's less than that price, any excess of qualifying expenditure over disposal value which would have been taken into account for making an allowance for the chargeable period, and so on. So in other words, what 78.2 is doing is saying, in that particular circumstance, and where an election is made, the amount of the sale price is open market value, or possibly a lesser amount. Now, I accept that when Section 78.2 operates, that does have an effect, potential effect, on the position of the predecessor, the deceased, his tax position. But the issue in my submission is not what happens when Section 78.2 applies, because what 78.2 is doing is altering the rule in 78.1. The real issue I would submit is, can the rule in 78.1 make a difference to the position of the predecessor? In other words, 78.1 isn't just there to introduce 78.2. 78.1 is the general position, and there's a difference made which alters the rule in 78.2. So it can't be said that 78.1 is affecting the position of the predecessor because of 78.2. It's 78.2 that's doing it. So that isn't a good answer to what on earth is 78.1 doing if, as a general rule, and subject obviously to subsection 2, it's not affecting the predecessor at all. Now, if I could, I haven't had the decency of taking you to any paragraphs of the upper tribunal decision so far, but if I could take you to what the upper tribunal said about that submission, at paragraph 50. This is in the core bundle at tab 7. Excuse me. So if one goes to 50 and the subparagraph 1 of 50, they're recording my submission that very closely section 78 is not concerned with the capital allowances of the predecessor at all. And if we go to what they say about it at 51, we do not accept Inmarsat's first argument summarised at paragraph 51. We're prepared to accept that in certain circumstances, the treatment of the predecessor prescribed by section 78.1 might be produced by a combination of 24 and 26, even if it were not separately spelled out in 78. Just stopping there, when they say in certain circumstances, they don't mention the possible other circumstances where 78.1 itself could produce a different result for the predecessor.
You say it really should be in all circumstances.
Yes. But then reading on. But even if section 78 does duplicate the effect of other provisions, it doesn't follow that 78 has nothing to say about the tax position of the predecessor. 78 provides an at-a-glance summary of important aspects of the predecessor's treatment for capital allowances purposes by using phrases that resonate for the purposes of determining the predecessor's disposal value. By treating the transaction as a sale and fixing the net proceeds, the provisions of 26(1)(a) are engaged so as to determine the amount of disposal value to be brought into account by the predecessor. Accordingly, 78 resolves any doubt that might otherwise have existed as to the predecessor's tax position by spelling out 1, the nature of the disposal event, 2, the time at which it takes place, and 3, the disposal value to be brought into account. So there's points there about an at-a-glance summary and resolving any doubt that might otherwise have existed. And my response to that is, that's not the way that this legislation operates. There is no other provision in the Capital Allowances Act which, as it were, signposts or replicates and just tells you, by the way, it's not done. Now, it's true, under the tax law rewrite project that came in subsequently, that was a technique that is used, signposts, telling you where you're going and so on, and sometimes reminding you or pointing to things. But that is not the way that this legislation works, the 1990 Act. And I would submit that there's absolutely no doubt that needs to be resolved. We looked at sections 24 and 26, and it was perfectly clear that on the permanent, the deemed permanent discontinuance of the trade, there is a disposal value equal to market value. You don't need to be reminded of that. That isn't what 78.1 is doing in my submission, reminding you, by the way. It's true, just to make this point, that by deeming there to be a sale, you could say, well, that's a difference, because before we were looking at a permanent discontinuance that didn't involve a sale, and that was under 26.1f. Now we've got a sale, which is under 26.1a, but that's nothing to the point, because that leads to exactly the same disposal value. The disposal value in either case is an amount equal to the open market value of the fund. So that can't be what the draftsman was doing, was sort of saying, I'm going to change the disposal value by changing the disposal event to make it a sale. That would be a pointless exercise. So in my submission, it's not about the predecessor, it's all about the successor. HMRC and their skeletons say, well, actually, there is that difference in section 78.2, I've made that point. But also they say it's perfectly understandable why the draftsman would want to spell out the position under section 78.1, given the existence of section 77. Well, I've taken you to section 77. That only applies if they're connected and they make an election. I would submit no one reading section 77 is going to think, oh my goodness, what on earth is going to happen if there isn't an election? They know that the general rules operate, and the general rules are the ones that I took you to, which is that there's a market value, disposal value for the purposes of the predecessor. And if section 78.1 was designed to clarify the position in the light of 77, why only do so if there isn't a sale? If you want to say what the position is when there isn't an election, you can't make an election under section 77. Why only do so if there isn't a sale? And why only do so? Why do it in terms of the machinery or plant being in use or available for use? Why limit it to those circumstances? If you're truly trying to give clarification, what happens if you haven't made an election? You don't limit it to those particular circumstances in my submission. That shows that's not what the draftsman is trying to do. He's not trying to give clarification at all. He's dealing with a specific case, albeit one where there isn't an election, but a specific case, and knows perfectly well that he's not making a difference to the position of the predecessor. So basically, my submission is, as far as section 78.1 goes, that it's the combination of the natural meaning of the words shall be treated as sold to, the fact that it's clear that it makes no difference to the predecessor, and therefore must be directed at the successor, and finally, the clear policy reason for wanting to put the successor into the predecessor's shoes. I've taken you to the other succession provisions which try to achieve that result. That those, in my submission, lead one to conclude that the assumption, the unstated assumption which HMRC say section 78 was working on is simply not there. The draftsman would not leave it to an unstated assumption, as we've seen from section 77.4. The draftsman spells things out, and that's not what he's done here. Could I then turn to my submissions on 61.4?
You could.
You remember why I'm looking at section 61.4 is simply because I accept that the 78.1, with the language and its purpose, is operating in circumstances where there is a disposal value. The draftsman recognises there is a disposal value for the predecessor, which prevents any more allowances being available to the predecessor, and the draftsman wants to deal with the fact that actually it's a succession, the trade is continuing. So there must be that actual or deemed belonging by the predecessor. So section 61.4 is on page 96 in tab 9. So the heading is machinery and plant on lease, but we only get to the lessee's position in section 61.4.
Sorry, you did say which page?
Yes, 96.
96. Thank you.
If I can read 61.4 and say what the issues are relating to it.
Yeah.
Where A lessee incurs capital expenditure on the provision for the purposes of a trade carried on by him of machinery or plant which he's required to provide under the terms of the lease, and B, it's not a fixture. We don't need to worry about that. Then if the machinery or plant would not otherwise belong to him, the machinery or plant should be treated for the purpose of this part as belonging to him, and so long as it continues to be used for the purposes of the trade. Now, it's clear that here we have an express deeming to belong, and we're told how long that deeming continues. And that reminds me, and I apologise, one of the points made against me by HMRC and indeed by the upper tribunal was that 78.1 doesn't do that. It doesn't tell you for how long the machinery or plant belongs to the successor. It doesn't have a for so long as or anything like that. May I, and I'm sorry to move around, but could I just address that point, given that I only recently left 78.1? Apologies.
Yes.
First of all, as the upper tribunal agreed, for the purposes of the successor being able to claim writing down allowances, there is no requirement of continuing belonging. Remember I mentioned that, right?
Yeah.
So that you don't need to say that it continues to belong to the successor for the successor to continue to qualify for writing down allowances. And given that we're looking at deemed belonging, the only possible purpose or function of a rule that says this is when it ceases to belong to you is to create a new disposal event. In other words, it can't actually cease to belong to you. You can't sell it. Then the purpose of a rule that says you no longer own it, it no longer belongs to you, is to create, as it were, a deemed disposal event. One of the disposal events in section 24.6 is it ceases to belong to you. The question is there a gap in section 78.1 because the draftsman has not said when it ceases to belong to the successor? In other words, is there a gap because the draftsman on my analysis, my submissions, hasn't created a time when there could be a new disposal event? And my submission is that isn't a gap in the legislation. That isn't a problem that I need to answer because there are all sorts of other disposal events which can still operate. In other words, losing of possession, that's one disposal event we saw in section 24.6. And another one is using it for non-trade purposes. So that if either of those occurs, or indeed a permanent discontinuance of the successor's trade, that's another disposal event. those disposal events can still operate in the real world, as it were, in relation to the machinery or plant which the successor is using. If he uses it for other purposes, that's a disposal event. If he ceases to have possession of it, then that's a real world disposal event. If his trade ceases, that's another one. All those disposal events can still occur. My submission is the draftsman simply didn't feel the need to create another one, a deemed one. For example, this one is deemed to belong to him so long as it continues to be used for the purposes of the trade. That creates a disposal event for the lessee, or in principle, it creates a disposal event for the lessee, which is not a normal disposal event, because if you cease to use plant for the purposes of your trade, but don't use it for other purposes, that is not a disposal event as a general rule. But the draftsman here wants there to be a special occasion where there is a disposal event.
And I'm afraid I wasn't keeping up with you. I was looking at something else.
Yeah.
So just tell me, where do you get that special disposal event?
Well, it's because what the draftsman has done in relation to something that deems to belong to the lessee here is to say there is that a deemed ceasing to belong on a particular occasion.
And where does he say that?
As belonging to him for so long as it continues to be used for the purposes of the trade. So if the lease continues, but the lessee ceases to use the plant for the purpose of the trade, then it no longer belongs to him. It ceases to belong to him. That's the effect of those words in 61.4. And the consequence of that is that when we go back to section 24.6 and see the various disposal events, one of them is the machinery or plant ceases to belong to him.
Okay. I'm getting myself confused.
Right,
Can I leave
sorry.
section 61.4 on one side for the moment? So can we go back to your case where the trade has been transferred, but the original trader has kept the property?
And obviously kept the property includes, it was deemed to belong to him, and therefore he couldn't transfer.
Can I leave all that out of it?
Okay.
Right? Just suppose it's a real...
A simpler case.
A simpler case.
Right.
So he's carried on the business with the benefit of property. Now he's transferred the property, but he's transferred the business, but kept the property for himself, and possibly is getting rental for it. What disposal events are there?
For the successor.
For the successor.
Yes. Ceasing to have possession.
Yes.
Beginning to use for non-trade purposes.
So ceasing to have possession is
a disposal event.
6C2.
Yeah.
Loses possession.
It sounds like it's an unfortunate event. Loses.
It does
possession,
rather. It sounds like you've dropped it in the street.
But in my submission, it applies to any case where you pass possession to somebody else, and it's expected to be permanent. So if you, for example, were to lease it out to somebody else, I can see why that should be a disposal event in its own right, or at least it is. And another one is using it for non-trade purposes. So
Is that one?
yes, so 24.6.
So that's 4.
4. So if one contrasts 4 there, for purposes other than those of the trade, with the disposal event, which in my submission, I know you don't want me to go there, but I'm just by way of an example, in 61.4, belonging to him for so long as it continues to be used for the purpose of the trade. If the lessee ceases to use it at all,
Yes, what happens then?
that is created by the draftsman as a ceasing to belong.
But if I leave on one side 61.4 for a moment, so the simpler case, where the original trader has kept the property, and there's a succession to the trade, and you say, well, at that point the successor starts writing down allowances. If he simply stops using the property, what happens then?
But keeps possession.
It keeps possession.
Right. And there's no permanent discontinuance.
No permanent discontinuance.
That is not a disposal event under general principles. And my submission is why would one think that that leaves a gap? Why would one think you need to fill a gap by deeming it to cease to belong to the successor at that point? So as to say, if you stop using it for the purposes of your trade, then we're going to deem you no longer to own it and therefore have a disposal event.
And so to speak, there is no disposal event corresponding to 6C1 ceasing to belong, because the original trader can do what he likes with his property. He's not getting the allowance anyway.
Yeah, the important thing is that the successor retains possession. Because, well, an important thing, because obviously that's one of the requirements of 78.1 in the first place, that he's using it or it's available for use in the new trade. And if it's not available because he's passed possession to somebody else, then that is a disposal event. So the important point is that the plant continues to be, I'm generalising slightly, but continues to be used or available for use in the trade. If that ceases to be the case, because of a loss of possession, then that will be a disposal event, a market value disposal event for the successor, and everything is fine. So that the fact that the draftsman of 78.1 has not said, and these are the circumstances where it ceases to belong, is in my submission not surprising, because the draftsman didn't want to, as I've put it, create a new disposal event different from the ones in
and just trying to think of situations which you might say are inherently highly improbable. Suppose the original trader owns a house which is used in the business.
Right.
Then he sells to the successor the business,
Yeah.
but the successor hasn't got the money to buy the house. And so the original trader keeps the house and charges rent. Then the purchaser decides he'd rather live there. What happens then? He's still carrying on the
trade. If the
trade.
decides to live there, then the... I mean, when we talk about a house,
Yes.
we've got to be talking about machinery or plant.
Yes, that's true, yes.
So let's just assume it's plant anyway, your example. The purchaser of this machinery or plant decides they want to use it for themselves.
So you say it's for purposes which are other than those of the trade?
Well, no, if the purchaser wants to use it themselves, then I'm assuming it would be pretty likely that the successor will no longer have possession of it because the purchaser wants to use it.
I'm getting muddled on my purchases. I'm taking the purchaser to be the successor. But the successor has gone to live there, so you say it's ceased to be used.
So the successor
for
is the
purposes.
purchaser in your example.
Yeah,
Later event. I do apologise.
No. So you say it's ceased to be used for purposes. Oh, no, hang on.
No,
It begins to be used for purposes other than those of the trade.
I see. So that you're postulating some private use on the part of the successor, now purchaser.
Yes.
Yes. In that case, yes, it begins to be used for purposes other than the trade, and that is a disposal event in its own right.
Yes, I see.
So I accept, and this is a point made by the upper tribunal, and I'm sorry I didn't make this earlier on, that Section 78.1, unlike, for example, 61.4, which says when the belonging ceases, and 154, which also says how long the belonging lasts, and therefore implicitly when it ceases, 78.1 does not tell you when, on my argument, the deemed belonging ceases. Is that a gap in the legislation? No, because the purpose of the deemed cessation of deemed belonging is only ever to create a special disposal event. You know, when is this ceasing going to occur? When something happens which is not otherwise a disposal event. The draftsman of 78 didn't want to create a new disposal event. He's perfectly happy with the ones he's got, which is as long as you keep possession of it and don't use it for a non-trade purpose, and your trade continues, then you carry on getting righted down allowances. If one of these things happens, then you may have a balancing charge or a disposal value. I'm sorry. I can now go back to 61.4 after
Yes,
that
thank you.
interval. I'm sorry. So, the requirements of 61.4. First of all, did IMSO incur capital expenditure on the provision of machinery or plant? That's the first question. And if I address that straight away, the upper tribunal said yes. Although IMSO only incurred launch costs, it nevertheless, those launch costs were capital expenditure incurred on the provision of plant for the purpose of the trade. And the reason was that although they're called satellites, when they're on the ground, they're useless. They're of no use. They're not plant. They are of no use whatsoever until they're launched into the correct orbit. So it was necessary to launch them in order for them to be able to function as plant in the trade. And that's not a disputed fact. That's accepted because it's it's accepted.
The necessity is accepted, isn't it? But not that there was capital expenditure on the satellites. That's not accepted, is it?
It's accepted that it was capital expenditure, but the word is on the provision.
On the provision.
Yes, that's not accepted. But just the factual point about the necessity.
You've got to launch them.
You've got to launch them so that they can be used as plant. So that the question is, what's meant by on the provision? My submission is, first of all, that the words on the provision, and indeed it goes on to say, which he's required to provide, those words provision and provide in 61.4 do not carry a special meaning different from the meaning throughout Part 2, which is all about machinery and plant. We saw in section 24 the reference to incurring expenditure on the provision of machinery and plant. 61.4 has no special meaning there. What is the meaning, therefore, throughout Part 2 of that expression on the provision of machinery or plant? My submission is that that word provision carries its ordinary meaning. It's not a technical meaning. So that if I and my friends decided to organise a party outside, and I said I volunteered to provide the marquee, that doesn't carry with it any implication of acquiring it, any ownership implication. The provision there is simply making it available for use. And that, in my submission, is the meaning of provision, and the expression incurred on the provision. It simply means expenditure incurred on making available for use as plant or machinery in the trade. That's why transport costs, which are necessary to get the thing to the place it's going to be used in the trade, are, as we see from the case law in a moment, or after 2 o'clock.
Well, that's a completely separate point, isn't it? The point you're making is when you provide the marquee, you're not saying I need to own the marquee or give the marquee to you to own. It just means it'll be available for use for the time that we need it. The transport cost point's a completely different point, isn't it?
Well, my submission is...
You could have the same problem with the... You could say just the same problem could arise with the marquee. Are you referring to the cost simply of hiring it from the tent company, or also of hiring a van to bring it from their premises to the venue? Am I being picky? They're not the same point, are they?
Well, perhaps I ought to leave that to when we look at what the House of Lords say about those sorts of costs. But in my submission, the words on the provision are wide enough to cover not simply, or incurred on the provision, are wide enough not simply to cover the costs of purchase or being able to use, but also other costs which are incurred on something which has necessarily to be done so that the thing can
Yes,
be
but I
used.
see that source of it. Yes, but I was just trying to understand. There are two quite. At the moment, I still at two completely different points. One is can the requirement for expenditure on provision be met by rental? That's one point. And whether or not you're talking about rental or purchase, does it include the necessary costs of making it usable?
Okay, well, my submission is that the ordinary meaning of provision, if I offer to provide the marquee, then I don't say, well, sorry, I didn't agree to transport it. If I'm going to provide the marquee, I've got to get it there to the party. And that may involve hiring it, or it may involve buying it. But that includes moving it from where I buy it or hire it to the venue
Yeah,
of
well,
the
I
party.
see that, and we're going to look at the cases at the moment.
It's just the ordinary meaning of the word provision covers things that are done or have to be done in order to make something available. Whether it's to do with paying a rent or a purchase price or other things as well. The upper tribunal, perhaps I could just make this point before the short adjournment. The upper tribunal was concerned about not having guidance about the underlying policy of 61.4. If I can take you to what they say at paragraph 60 to 63 of their decision. If I could just ask you to read those paragraphs.
Yeah.
And the upper tribunal come back to that later on in their decision. Obviously, it didn't prevent them deciding the points they did about 61.4. My submission is that an inability to identify a reason why a lessee in the position mentioned in 61.4 can get allowances because the plant is deemed to belong to the lessee. Because it's not spelt out in the legislation. An inability to decide what that particular policy reason is, why is there that deemed belonging in the case of that lessee, isn't an obstacle to interpreting 61.4. Now, HMRC say in their skeleton that they've actually done some more work and answered that query which the upper tribunal had. I submit that what they rely on doesn't solve that problem, doesn't answer that point at all. If I can take you to what they rely upon, which is at tab 18 of the bundle of authorities. Now, this is an extract from Hansard. There's under the heading clause 43, clause 43 is a what became a provision of the 1971 Act, Allowance Act, 1971, which subsequently became Section 68. Sorry, 61, Section 61. And it says, Clause 43 reforms the rules for giving capital allowances on leased machinery and plant, giving the allowances on each asset to the person, whether lessor or lessee, who actually incurs the expenditure on it, a result which has not always followed, as I explained in committee, under the existing law. Examination of the clause has, however, revealed a defect in the new scheme, which the 3 amendments are designed to cure. Just stopping there, just to say that this gives allowance to the person who incurs the expenditure, does not tell us about the policy reason behind deeming the lessee to be the owner when he wouldn't otherwise be, and therefore getting allowances. Doesn't tell us that. And then it goes on, Clause 43.2 provides for the case in which the expenditure is incurred by the lessee. The most common case of this is the long lease of a building with an obligation on the lessee to replace, as they wear out, various items of plant, for example, lifts, central heating boilers, and so on, installed in the building. 43.2 gives the lessee the title to allowances on any item which he replaces by treating it as if it belonged to him, so as long as it's in use for the purposes of his trade. That's the crucial point. But in reality, the replacement item doesn't belong to the lessee. It becomes the property of the lessor, to whom it's to be surrendered at the end of the lease. The clause as it stood recognised this by providing that on determination of the lease, no disposal value was to be brought into account against the lessee. So far as it went, that was right. But at the end of the lease, the lessor has acquired a possibly valuable piece of plant or machinery, which if he wishes, he can dispose of. Since he hadn't incurred the capital expenditure on the plant or machinery, there was nothing in the clauses as they stood to require him to bring into account any disposal value if he disposes of it. Then it says the amendment remedies this situation and so on. I don't think that any of those amendments really tell us about why the lessee gets allowances in the first place. Now, so actually, if you ask the question, why is it, this was the question the upper tribunal were asking, why is it that the lessee is in that privileged position of the plant being deemed to belong to him so he can qualify for allowances? This doesn't tell us, this doesn't answer that question at all. The reality is HMRC are relying upon this extract from Hansard to argue, and they do repeatedly in their skeleton argument, that Section 61.4 has only a very narrow scope, and it's all about replacement. The minister here says the most common case of this is the long lease of a building with an obligation on the lessee to replace various items as they wear out. That's the bit I've just read out. To say that that's the most common case is not to say, in my submission, that's what it's all about, replacement. That would be a misreading and an improper use of Hansard. Perhaps that's a good point, given that it's 1 o'clock, to stop.
Yes, thank you. Very well, we'll sit again at 2.
Court rise.